is any FIR is registered against you or any false case is registered against you, a person who has a malice intention against you lodged a fabricated FIR, what remedy you have? Dear friends, welcome back. This is IndusLex. I am Vikrant Pratap Singh, and today I am going to discuss how to defend yourself in the criminal cases, how you can effectively defend yourself in the criminal case, and what is the proper procedure to get justice when a criminal case or false case is registered against you. Dear friends, if a case is lodged by the private individual or a case which is lodged by some authority, these are the two different cases. I hope that a private individual has lodged case against you, because if there is a state case such as Gangster Act or in the Arms Act or Explosive Substance Act, or we can say the Prevention of Cow Slaughter Act or a Prevention of Corruption Act, these cases are at different footings, and there are some several guiding factors beyond these cases. We will discuss all these cases individually in separate video, but today I am going to discuss those cases which is lodged by a private individual. Dear friends, no matter that a case is lodged by a private person, all cases which is registered in the form of first information report, that are state case, and basically state government is prosecuting you or a central government prosecuting you in that case. But if there is a private complaint, he is informant and he maliciously prosecuted you in this case, then what remedy you have, how to approach the court, how you can say that you are completely innocent. So dear friend, be remember, whenever an FIR is lodged and if it is completely malicious against you, you have a ground that this case is a result of malicious prosecution, and you can approach the court invoking writ jurisdiction in the Honorable High Court and make prayer for quashing of the FIR. So, if the FIR is registered against you and it is a result of malicious prosecution, you should definitely invoke the writ jurisdiction, invoke the door of the Honorable High Court and get quashed your FIR. So whether only by saying that this case is false and court will going to believe you, or there is some guiding factor. Dear friend, it doesn't matter how much case is frivolous or a false, but court will see whether there is offense is made out or not, or there is a prima facie evident that this case is a sheer abuse of the process of law, then court is going to quash your case. However, it doesn't matter the case is malicious, frivolous or not, but if a case is registered against you, you should also watch this video, because I am going to tell you how to protect yourself in the criminal prosecution. Dear friends, you have to understand that if an FIR is registered, you firstly have to point out under which section the FIR is lodged. If the FIR is lodged under those sections which are punishable under the law less than 7 years, then you have to be very cool. I can say that at least police is not going to directly arrest you. Such cases are, which are generally a false, is relating to the domestic violence cases, dowry cases, where whole family members are prosecuted on only on the basis of a statement of a woman who said that these are the family members and they demanded dowry and tortured her, so you have to face the prosecution. Or some other cases in which your neighbor or a person who has a malice intention against you lodged the FIR. So you have to point out whether the FIR is registered under those sections which are punishable by the less than 7 years of imprisonment, then police is not going to arrest you directly. By the definition, FIR is registered for the cognizable offence, and cognizable offences are those offences in which police can arrest you without warrant. But when we read further, it says that if the offence is punishable by less than 7 years of imprisonment, then police is not going to directly arrest that person. He has to give him a notice regarding that you have to appear before the police on such date at such place, which is mentioned in the notice. And police generally in these cases is not going to arrest you after the judgment of Honorable Supreme Court Satyendra Kumar Antil versus CBI. Satyendra Kumar Antil versus CBI, during the investigation, he relied upon the another Honorable Supreme Court judgment, that is Arnesh Kumar versus State of Bihar, in which Honorable Court has specifically mentioned that jail is an exception. So, if an offence is punishable by less than 7 years of imprisonment, police authority is going to give you a notice. And if the offence is punishable by more than 7 years of imprisonment, then don't do mistake that you appeared before the police without any protection order from the any court of law. Because if the offence is punishable by more than 10 years, then it is a mandatory duty of the police officer that he is going to arrest you. So don't do this mistake. If you get knowledge that an FIR is registered, you are very lucky, because sometimes people even don't know that FIR is registered against him, and police came and arrest that person. After got arrest, he get knowledge about his arrest, and it is also the mandatory part of the procedure that whenever police authority arrest any person, he will inform him about the reason why police is arresting him. So let's come on second aspect, that if the FIR is lodged, it doesn't matter it is a false or correct, but you have to protect yourself. So what you have to do, you have two remedy to protect yourself, or I can say that you have two remedy to protect yourself from jail. First remedy is that you can approach Honorable High Court and get stay order from the Honorable High Court, or you can approach the jurisdictional session court for the anticipatory bail, that the bail which is granting you by the court in event of arrest, that on the basis of bond you will not send to the custody and participate in the investigation. So what will be the best option? The best option is always that the criminal writ jurisdiction. You have to approach the court, challenge the FIR and pray for the quashment of that FIR. If it appears to the court that it is below 7 years, then Honorable High Court direct the investigating officer to comply with the order of Arnesh Kumar versus State of Bihar, that he will give you a notice, and if you participate in that investigation there is no need of arrest. And if court finds that FIR is completely frivolous or no offense is made out, then honorable court may grant you the stay order. Secondly, if you not get succeeded in the criminal writ jurisdiction, then you have another option left, to approach the session court and apply for the anticipatory bail. Always remember, these two remedies are entirely different remedy, and it is not barred that if you apply for the anticipatory bail you can't come before the honorable court for the quashment of the FIR, or if your quashment of the FIR petition is dismissed you can't approach the honorable courts for the anticipatory bail. One jurisdiction is extraordinary jurisdiction. One right is an extraordinary right given to you by the Constitution, that if any false or malicious prosecution is registered against you, then you can get the quashment of that prosecution, because criminal prosecution is very serious matter, and nothing is more dangerous than the criminal prosecution which is made by the human. So it is a constitutional right that whenever a false FIR is registered against you, you get the quashment of that FIR. And if you not succeeded in the quashing of that FIR, then you can approach the session court for the anticipatory bail. And if you not get succeeded there also, then you can again come before the Honorable High Court for the anticipatory bail. There are certain circumstances in which you can directly approach the Honorable High Court directly. These circumstances are: if there is a rejection of anticipatory bail by the session court of the co-accused, then you may directly approach the Honorable High Court of the competent jurisdiction on the basis that the co-accused person approached the session court, but that person is not succeeded in the session court. Therefore there is no chance of succeeding my application. Therefore I came before you to get the anticipatory bail. Second case is that if there is long adjournment in the session court, there is no chance of hearing due to strikes or some other unforeseen circumstances, that there is no hearing, then in that cases you can also approach before the Honorable High Court for the anticipatory bail directly without availing the remedy before the session court. And if the FIR is registered in some different district or different states where you are not residing, then you can approach the Honorable High Court of that jurisdiction directly without availing the remedy of anticipatory bail in the session court. These are the circumstances in which you can approach the Honorable High Court directly for the anticipatory bail. But always remember, it is always be good for yourself that you should first apply anticipatory bail in the session court of the competent jurisdiction, and if you not succeeded there, then you come before the Honorable High Court. And if the anticipatory bail is not allowed by the Honorable High Court, then don't lose the hope. There is apex court also. Apex court can also grant you the anticipatory bail, but that procedure is somehow typical, because there was entirely different proceeding. You have to file an SLP, that the special leave petition. When a special leave petition is admitted and a criminal appeal number is registered, then that case will be heard. So that is very hectic procedure. In 99% cases you get relief from the Honorable High Court, and in exceptional cases, in exceptional circumstances, it happens that the anticipatory bail is not allowed, and that will be allowed by the Honorable Supreme Court. So whenever the FIR is registered, you have to challenge that FIR. You have to tell the court that look, there is no offense is made out, and even though if the offense is made out, you have to say that this is a case of malicious prosecution. There is a civil dispute which given color of the criminal nature or some other ground, whatever you have, depends upon your case. And if you not get succeeded, then you have to apply for the anticipatory bail. Why you have to apply to the criminal writ jurisdiction for quashment of the FIR? Because even if there is if the FIR is registered under those offences which is punishable by less than 7 years, then you can't apply for the anticipatory bail. Actually you can apply for the anticipatory bail, but court will say that look, this is a below 7-year offence and there is no apprehension of arrest, so your anticipatory bail is not technically maintainable. And what if the FIR is registered under those offences which is punishable by less than 7 years, but during the investigation, if investigating officer change or alter the section, and that section is punishable above by more than 7 years, then it will be dangerous for you. So whenever an FIR is registered, you firstly come before the court and try your luck. Even if you don't get anything, you get the direction that the investigating officer, without complying the guideline of Arnesh Kumar versus State of Bihar, you should not arrest. And when you get an order from the Honorable High Court, even though after that if there is alteration in charge, alteration in section, then without getting prior permission of the session court or a magistrate court, that person, as the case may be, because some cases is triable by the session court and some cases is triable by magistrate court, and and at the initial stage during the investigation before the filing of charge sheet, that cases are dealt with the magistrate. But if that cases is relating to the POCSO or SC/ST Act, you have to approach that competent court. Your lawyer will inform you where your case is pending. So when you come before the court and even you get a simple direction that investigating officer is directed by the court that this investigation must be done in the light of Arnesh Kumar versus State of Bihar, then even if there is enhancement of section which is punishable by more than 7 years, you will not be directly arrested by the investigating officer. He has to approach the competent jurisdictional magistrate to get NBW, non-bailable warrant. And if you don't approach to the Honorable High Court, then he no need to approach the jurisdictional magistrate to get arrest to get the to get to arrest you, because it is by the definition that that FIR is registered for the cognizable offence, and that cognizable offences are those offences in which police may arrest without warrant. And it is always good for you that from initial stage of case, at least you have challenged that case, that this is a false case. Now come on the second stage. It is, first stage is that FIR is registered, and during the investigating in during the investigation. Second stage is that after completion of investigation, police submits its charge sheet. When the investigation is completed, investigation is completed when there is record of the statement of the witnesses, recording of the statement of the informant. If there is some medical injury or medical medical aspect, then the recording of the statements of doctor, etc., as per the case. And most important thing is that there must be recording of the statement of the accused also. So when the offense is punishable by the imprisonment of less than 7 years, investigating officer will comply with the order of comply with the direction of Arnesh Kumar versus State of Bihar, and record your statement. And if the offense is punishable by more than 10 years, then to record your statement he has to take you into the custody, because offense is punishable by more than 7 years, and he is duty bound to arrest you. To at the instance he met you, he will arrest you and then record your statement. So if the offense is punishable by more than 7 years, then you have to approach the high court or and get the stay order. Then you approach the investigating officer, and investigating officer, after getting that order that he cannot arrest you, he will record your statement and complete the investigation, submit the charge sheet. If you don't get the stay order, you have to get anticipatory bail. When you get the anticipatory bail, then investigating officer records the anticipatory bail order, complete the procedure of anticipatory bail, and then record your statement and completing the investigation, and then send the charge sheet to the magistrate. So for the completion of investigation, there must be the statement of the accused in the case diary. And what if the accused will not find by the investigating officer? He can take the process of 82 CRPC, that he can pronounce you as a absconder, and then he may able to submit the charge sheet. Meaning thereby, for the completion of charge investigation, there must be the statement of accused in the as part of the case diary. And if there is no statement of the accused, then there must be the proclamation of offender section is invoked. And if you have get the stay order or anticipatory bail order, so there is no issue at all. Once a charge sheet is submitted and competent jurisdictional magistrate has taken cognizance on that charge sheet and summoned you, then you again have a chance to challenge this entire proceeding. And look, this time this cognizance order, this summoning order, first time a judicial magistrate has taken cognizance. Before this, ball is in the hand of investigating agency, in the hand of state. From this stage, that is stage 2, the ball comes finally in the hand of judiciary, where the jurisdictional magistrate has taken cognizance. Therefore, again you have a chance to challenge that, entire proceeding when charge sheet is submitted before the competent court and competent court has taken cognizance and summoned you. You have to take that cognizance and summoning order, charge sheet and FIR along with case diary, and challenge the entire proceeding, whatever manner, whatever ground you have. Sometime you may falsely implicated in that case, in those cases in which on the time of occurrence, on the time of incident, you may be at some different place. So maybe you feel that it is a big ground, it is a very good ground, that at the time of incident I am in some other city or some other location. But remember friend, as in the initial stage when we deal with the quashing of FIR, only two ground will be worked for you. First ground is that for perusing the FIR, there is no offence is made out. There is no disclosure of commission of the cognizable offence, or you have a very good evidence to show that this is a frivolous and malicious prosecution. Now again at this stage, even if you have a evidence, you have a CCTV footage, or you have some witnesses who testified before the, who can testify before the court that look, this man on the date of occurrence is at that place along with us, it doesn't matter. Again, from perusing the entire case diary, if there is no offence is disclosed, then you get relief. Or if there is a prima facie evidence that this case is a frivolous and malicious, then you get relief. Alibi is no defense at all at this stage where we demand quashing of the criminal proceeding. Then what to do? If you get the quashing of that case, it is so good, but if you don't get the quashing, then what have the other remedy you have? At this point, you may seek permission from the court when court is going to dismiss your quashing petition of the entire criminal proceeding, that for relief for filing the discharge application before the trial court. Stage of discharge is just come before the charge, stage of charge, framing of charge. When a cognizance is taken, you have been summoned by the court. When you appear before the court, you have to apply for the bail. And if you are already on a bail, then court will tell you that look, I have got the papers, you have committed this offence, and I am going to prosecute and initiate trial against you under this section. This stage is called framing of charge. So when you challenge the entire criminal proceeding and you are at the worst that you are not going to be succeed in this quashing, because whatever ground you have is not going to read at this stage, because no additional paper, no other material apart from the case diary is perused by the court within the ambit of law at this stage. So even if you have a CCTV footage that at the time of incident you are not there, that cannot be perused by the honorable court while deciding your quashing petition or a quashing application. So what will be the stage when you can give your evidence? This stage is just before the framing of charge by way of discharge application. In a discharge application, dear friends, you may give your additional evidence apart from the case diary, and court will consider your additional evidence at this stage. And dear friends, remember, once charge is framed, then prosecution witnesses, that informant, police witnesses, others will be examined in the court, and your advocate will be cross-examined them. Then a stage will come on which, after the completion of whole prosecution evidence, judge again asked you that these are the evidence, what is your defense, what is your version. That version, whatever you tell before the court, will not be read against you. But remember, the first instance when you have a right to tell the judge about your version is that just before the framing of charge by way of discharge application, where you can give also additional evidences which you have. And if the story you narrated, the defense you narrated at this stage, at the stage of discharge, and will be met after the whole evidence is recorded, when judge asked you what is your version, which is not going to read against you, even though if some admission is made by you which is against you. If these two stages, your story, your version is matched, then there is a good chance of your acquittal in the trial case. So what I am trying to tell you, dear friends, you have three stages before actually the commencement of the trial. First, you can challenge the FIR, get the quashment of the FIR. Second, you can challenge the entire criminal proceeding along with cognizance and summoning order along with FIR and get the criminal proceeding quashed. Third, you may apply for the discharge, and if your discharge application is rejected by the trial court, you can challenge that application before the Honorable High Court and subsequently to the Supreme Court. Always remember that any order from which you aggrieved can be challenged in the Supreme Court. Suppose that you have challenged the FIR in the High Court, and you don't get succeeded, you can challenge that order by way of SLP in the Honorable Supreme Court. Police has completed the investigation, submitted its charge sheet before the jurisdictional magistrate, and the magistrate has taken the cognizance of the charge sheet and summoned you. And you challenge the entire proceeding along with that cognizance order before the Honorable High Court, and Honorable High Court is not make order in your favor, then you can challenge that order in the Honorable Supreme Court. And if you not get order on merit and get a direction to file a discharge application by way of advocate, or if you are in bail, you get by way of, after getting bail you file a discharge application, then that discharge application, if you will not get discharged by the trial court, then you can challenge that discharge order before the Honorable High Court. And even if you not succeeded in Honorable High Court, you can challenge that order in the Honorable Supreme Court. These three steps is a very crucial and very important, and it will help you to protect yourself, to understand yourself, for better preparement. You get lots of time. If you deliberately participated in these three steps, it will take more than a years, and you can understand what the case is, what other evidences you can have. And even you, when a first time if FIR is lodged, person has no idea which advocate to hire, how to get face this prosecution. At least before the commencement of the trial, you have good knowledge about the court, you have good knowledge about the advocate, you have good knowledge about the law, so you can better fight your case and get acquitted from the case, even if you not get succeeded in the quashing of your criminal proceeding. Thank you.